Hey man, here we go. We're back in the building. Y'all know what to do. We're looking all crispy and clean on the screen. And it is Friday Eve. Shout out to everybody who's in the building. So good to see y'all. You know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're about to go ahead and get into it. Shout out to the gang. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, at patreon.com/ClassEbeats. By the way, the link is in the description as well as in the pinned comment in the chat. We're going to get into it today. Breaking news somewhat. Donna's not going to testify. I know y'all are so disappointed. I'm kind of disappointed I'm not going to get to hear from Donna, but it's probably for the best. We're going to be talking about that today. We're also going to get into the continued testimony from one of her former attorneys, and it's just very interesting as we move forward. We're going to hear testimony, a lot of testimony today. We're going to see if the defense can finally get it together on their side. But before we get into the show, I gotta say what's up to the people, man. Shout out to everyone who's in here. Let me see who we got. You know, we've got my awesome, amazing Amy in here first thing in the morning. Shout out to Amy. We got J Money up in here, J Bugmaster. The J's are here. We got Just Saying with Alicia Bombay. Good to see y'all. Les Cleaver. We got Trisha and Blue is in here. Dang, we got everybody in the building. Slim Life's up in here as well. Shout out to Tanya. Who else we got? Oh my goodness. And Amy and Les are already gifted memberships as well. I know I probably missed some of y'all, but I'll be saying good morning as we go throughout the show. What's up, Kara? Shout out to Kara and Blue. I see Michelle in here. So if you are new to the show, I don't ask for much here. I really don't, I promise. But the one thing I do ask is that you like the video on your way in. Likes are free. They help the channel continue to grow. They let the algorithm know that y'all are enjoying the show, and it shares the video, this live stream, and the entire channel with more people. So thank you to all nearly 1,100 of you that have liked the video. Hey, where else do they have 1,100 people liking the video before we get started? That's because I beg y'all for likes all the time. Amy's in there reminding you too. So we're going to go ahead and get into it. Also, if you're feeling extra generous, you can share the video as well. Just click the share button. It's got the little arrow pointing to the right. That'll allow you to share the video out on YouTube, on Facebook, on Instagram, on X, and you can even share it to your group chat via text. So thank you to all of you who have done that. I see some of y'all over on X sharing it all the time as well. I appreciate it. I will be reading super chats as we go throughout the show too. So thank you to everyone who just dropped some super chats. I see y'all in there showing major love. We've got my awesome, amazing Amy gifting memberships first thing in the morning. Thank you, Amy, for the love. If you got a membership from Amy, you know what to do. Say thank you, show her some appreciation, and make sure you check out the members only content we have here on the channel. You also get your name highlighted in green in the chat, and you get instant access to all the videos we drop here on the ClassE YouTube channel. So thank you, Amy, for the love and support. Les Cleaver gifted 5 memberships as well. Always in here showing up and giving y'all a chance to check out the member side. So thank you, Les Cleaver. Thank you to Amy for the support. All right, I'm not gonna waste any time. We're gonna go ahead and get back into it. It's a little bit of a rewind to yesterday. We got attorney Linda Bailey is in here, and we're gonna see what Linda has to say. This is going to be interesting. So we left off, Linda was talking a little bit more about her relationship with Wendy, her relationship with Donna, what she saw, what her experience shows in family court. And now we're going to get into more of the details of what she saw from Donna herself. Let's get into it.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement
That's a
accounts. I have
fact.
one right now. And he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
Saves a lot
So
of
in that
trouble.
type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where
Makes
somebody's
sense.
been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendy Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe, Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as
With
Ms.
all
Adamson
due
said,
respect, Linda,
often. Sometimes it's employer involvement. Maybe
your
they're very
opinion
attached to
doesn't
their employer
matter
and
here.
they want to nurture them, or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would
Is that what gibbers
file
mean?
a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said,
great point, Vintage.
He didn't deny not paying, but he said, her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing
we saw the
clients,
emails.
how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they are very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion, and generally they don't. And I say, this is why I don't think that advice is valid or is going to help you, and we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendy
trying to normalize
was sent
Donna's
by her
control.
mother. Did you see evidence that Wendy shared those with Kristen
Very
Adelson?
strange.
I saw no evidence that Wendy shared them.
Okay. And did you speak with Ms. Adelson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
So she's controlling. She's a typical Jewish mother. Their words, not mine. All right. Y'all don't come after me for that. But at the same time, she's somehow not involved in her daughter's divorce. She created dating profiles using her daughter's pictures, her name, image, and likeness, and was trying to find men for her, but she wasn't involved in her divorce. What? Guys, this is gaslighting at the simplest level.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more...
I could go on.
I think it was more like 45, 55, something like that. It was, instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time. Exactly.
And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling
Mr.
Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st,
That's not what Donna said.
Did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
Okay.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking
She wanted their money.
for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation be dismissed. So,
Now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen
Wow.
$35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that. Okay. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few month period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days.
Are y'all buying it?
It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief did include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness?
She said sure, like Ms. Hilton. Sure.
An approach with courts, one states demonstrative A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line. But then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here, she's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
Does anybody know what this has to do with Donna? I haven't heard Donna's name in a minute.
And what were the possible repercussions to Mr. Markell?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Can somebody find Donna?
Were you provided with a
she?
series of emails in mid-December of 2013 where Mr. Markell emailed the parenting coordinator and Wendy Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kid said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendy Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that, to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to ClassE, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Okay. Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of Old Bar somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle to overcome.
And it had impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendy on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them, and they were little babies. And he didn't like that because he wanted to be able to go to the child care during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed a motion to dismiss on March 10th to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
Motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that, I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
She has a good memory.
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show a material and substantial change in circumstances, and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
He was going in.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that, because he's talking about what purportedly a 4-year-old may have said to him. And I think even in this motion, he says, I don't know if this is true or not. I don't know if Wendy was present or not, but I would like Wendy to make it stop if it's true.
Did this motion, the March 26, 2014 motion, that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal.
If this is all true, then why did Donna hate him so much?
And then he kind of tied in this grandparent thing on point 8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school, so he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendy to have to call him so he
Or
could watch the
something.
kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
And I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if, my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing, and so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each
That makes sense.
parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only
Yes.
in one occasion I can think of, and he was a convicted child molester.
It happens a lot.
What is your opinion about the persuasiveness of the March 26, 2014
Only
motion that
one
Mr. Markell
time?
filed?
I know somebody who
I
that's
think it
happened
would
to.
have
I
been
don't
similar
believe
to
that.
what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all because it was a complete waste of everyone's time and money and emotion because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No,
What?
I think when I was making notes, I put insert eye roll here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristen because, again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense, and I wanted to get Kristen's take on that and see if she agreed, and she did, and she said that she had advised Wendy of that, and that's what I would have expected from her.
Okay. In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna
Grandparents get
Adelson
restricted
was
all the
aware
time.
of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendy had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions because, like Ms. Adelson said, relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markell have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markell have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the
Forensic
judge tells everybody to
investigation,
behave
probably.
themselves and sends them on their way.
Florida is a wild place, man.
So we've talked about this not being a hotly contested case or a high conflict case. how many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markell that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Okay. Do you know how much in attorney's fees Wendy Adelson incurred, attorney's fees and costs, for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
Okay. In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Your Honor, may I show the witness the demonstrative?
You may.
Volume 1, Volume 2, Volume 3,
Ooh, that's a lot.
Volume 4, Volume 5.
Is there a question for the witness?
Do you recognize this file?
Yes, I think I forwarded.
Just
this
said, "What are you
to
doing, brother?"
you.
And these 10 volumes, a example of a hotly contested relocation case.
Well, I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got printed.
So the
What a waste of
clerk's
paper.
file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please, yeah, let's vote.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
He said no.
Judge, we're entitled to make a record. I believe I
No
have the...
speaking.
Members of the jury,
objections.
bailiff will take you into the jury room.
Oh man. We usually don't watch when the jury's out, but we're gonna watch it this time. Judge Everett is about to get on his you know what. Are we gonna be able to hear it? Oh no, we don't get to hear it.
The relocation issues within this case are certainly relevant as to a separate other case.
Here we
What
go.
is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendy Adelson and Mr. Dan Markell.
Kappelman, any other argument on this issue?
Just relevance, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
He mumbles something under his breath. He is not happy about that.
Ms. Bailey, please step down, step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room. Please approach.
Uh-oh. Judge Everett must have saw him over there mumbling. Oh, this attorney is about to get a verbal whooping from Judge Everett. I can feel it coming. Let me see if they go to break.
And you do not make.
Here we go.
I'm going to remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom. Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
I didn't stretch my leg, dang. No, Judge Everett is not having it today. Let's see. Okay, so they went to take a break. Let's skip ahead here. Let's see when we get back in. Uh-oh. Oh, Georgia's gonna get up here? Oh, man. Now we got the cross-examination of this witness, finally. Because, man, she was up there saying a whole lot of nothing that had anything to do with Donna. There's no reasonable doubt.
Everyone can be seated.
None.
Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markell divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar
Come on,
cases that have had
man.
anything from 2-day to 7-day trials. I've had them range from
Not true.
$200,000 to $500,000 in fees and costs. I've had multiple financial
Not true.
experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no
They
foundation
were
for
baseless.
those asks.
This is the word
Nothing
I think
further,
you're
Your
looking for.
Cross-exam.
Uh-oh, here we go.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Miss Adams.
Excellent point. If you're a doctor and someone asks you, hey, doctor, you had to chop this person's leg off. What do you think about that? I mean, their leg got chopped off. That was insane, right? The doctor's like, no. I mean, I'm a doctor. I chop legs off all the time. I mean, think about chopping off people's legs. Just wasn't a big deal, right? But yeah, but doctor, they had an infection. And you had to clean out this major infection, right? Yeah, I mean, so what? It's what I do. But if you ask the person that's over there losing their leg, they're going to be like, oh, this was insane. This was absolutely crazy. This is the wildest thing. I can't believe I'm missing my leg. This is wild. They're not thinking about the 120 plus other cases the doctor has done. No. How did it actually affect them? Excellent point made by this prosecutor. I wasn't even thinking about that from this aspect. This is someone who's probably numb to divorce proceedings at this point. To Charlie Adelson, to Wendy Adelson, and to Dan Markel, totally different world. To Donna Adelson, totally different.
Agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties, it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people
This is
whose
great.
lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are
That's what
impacted
she
by
said.
the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am,
She's
could you
cooking
please
it.
answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's
Yes.
lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right?
She's cooking this lady.
You can't agree with
Perhaps.
that. You can't agree with it. Strike the question.
Wow.
You were asked.
Zing.
Let me ask you this. Let's go on to something else.
Sheesh.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after
Middle
the petition
Eastern
was
person.
filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling,
Exactly, Ms. Bailey. To
Derived.
that person, it was a reason to commit suicide, right?
apparently so.
Wow. God, gee.
Aren't
This lady
these
is
issues
brutal.
raised in these pleadings potential fuel to make people upset?
Yes.
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
Exactly. You have no soul.
It shouldn't have been.
Jesus,
There was
man.
no proof,
It shouldn't have been in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Dang. Oh, she about to make me
Gibbers,
cuss.
according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No.
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
Depends on who you are.
Exactly. So we'd have to ask the parties, right?
Look at the lady
Right?
behind Georgia. She's like, "Dude, this cannot
Yeah, I
be
think on that issue,
real."
he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that we need to strike.
I'll
What is
rephrase
the-
it.
what is
Was
the objection again?
It's an improper comment on that witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened.
So, yes.
I've seen one
To answer your
person
question.
in my career go to jail over child support.
So she's only seen one person that's ended their life because of a divorce. She's only seen one person that's gone to jail because of not paying child support. In her 37 years, by the way, she's only seen one grandparent. This lady, this is embarrassing. She's only seen one grandparent that hasn't been allowed to see their kids. Embarrassing. Out of nearly 2,000 cases, a minimum of 2,000 cases she's seen. She's saying only one of each in her career. Get out of here, lady.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013, after July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
Yo, this lady is brutal, man.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
Answer the question, Miss
if there
Bailey.
wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
She said zillion.
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be
Jeez.
nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled, the witness has provided an opinion. State
Well-
the cross-examine.
Doors open.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing, so once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
She
Can I have
doesn't
a minute to
care.
confer, Judge?
Jeez,
Yep.
man. She does not care. Oh my gosh, this is brutal. This prosecution team is top tier. Amazing. She can't even put some. I will say she's the only one I think that called Danny Professor Markel. But goodness. That was brutal. I hope she's not done.
Nothing further, Your Honor.
Ah, man.
Briefly, Your Honor.
Go ahead and take her out the oven. She's cooked.
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new.
No. Nope. 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 That's a lie. Get her off the stand. She's perjured herself. She's referenced that testimony multiple times.
New information.
This
Nothing
lady.
further.
Will this witness be recalled at any point?
She's like, oh yeah, just like Kristen said earlier. Man, get this lady out of here. Shout out to Georgia going ham on this witness. It was a complete waste of time. And shout out to attorney 403. That was absolutely terrible. Let me know what y'all think about that whooping she just got in the comments and in the chat. Okay. Are y'all ready for closing arguments? Is it that time? Let me double check and make sure we're good. Shout out to everyone who liked the video, by the way. We got 1,400 of you in the building and 1,000 of you have liked the video. If y'all could take a second, please, and like the video. All right, it's free. Yeah, we had attorney Linda 403 Bailey up there. My gosh, that was garbage. All right, let's get to closing arguments. I know y'all can't believe it's that time. If we have time during verdict watch, we might go back and watch some of this other testimony from the defense. But they really, their case was, there's nobody moving forward we're going to hear from that is just life-changing. We've got Donna's former attorney worried about her mental health. We've got Donna saying she's not going to testify. Do y'all want to hear? Y'all want to hear Donna real quick? Hold on a second. How long is she talking for?
Ability will be placed.
Let me see.
I think not. If they rest without calling any further witnesses, that could change if the sales decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You don't
You
want
understand
that.
that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys, the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't, so I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you are in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify.
Shout out to Judge
But
Everett.
ultimately, you must choose whether you will testify or not.
I'm just waiting for him to say, whether or not you testify has nothing to do to me. I'm going to leave this courtroom today and I'm going to get dinner and I'm not going to think anymore about this. So, Miss Adelson, if you would please make a decision. Thank you. I love Judge Everett. Oh, he's the
This has already
man.
been discussed, man. What is your choice?
Judge Everett is amazing.
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
He said no. Tell him no.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
Yo, that's Judge Everett. Can we get Judge Everett in the chat? Man, y'all show some love to Judge Everett. Hold on. We're going to skip forward these exactly 5 minutes, as he said. See what Donna had to say. Oh, my God.
What is your decision concerning these 2 rights?
Judge Everett is the man. Oh, my gosh. We need to interview
Mrs.
Judge
Adelson, the
Everett.
question remains.
I
As
love
it
a good
relates
judge,
to your
man.
right to remain silent and your right to testify, what is your decision concerning these 2 rights?
Sit down and shut up, Donna. They got your cell ready for you.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way.
It will
We'll
be.
bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Judge Everett's the man. He said, your situation is no different than any other criminal who's been in the courtroom. Oh, Judge Everett is amazing. And if you don't make a decision now, legally I can't make a decision for you, but I most certainly will. Judge Everett is the man. All right, let's go ahead and get into closing arguments. As if we didn't have enough enjoyment seeing Georgia absolutely cook Attorney Bailey. Now we have closing arguments finally at the end of this trial. And you know she's about to go in again. Glad we get to see her in closing arguments. Can we get a round of applause for this prosecution team? Absolutely flawless investigation. Flawless case presented. And I want to know what you all think. Even in light of that, I know some of you may believe that they haven't proven beyond a reasonable doubt that Donna was involved and she's guilty of what they're saying she's guilty of. Well, let's go ahead and get into it and find out what they have to say. Man, what a ride. I think we're going to hear jury instructions first. Oh man, Donna. Donna.
Everyone can be seated. Good morning, members of the jury. Good morning. Before we get started with the instructions on the law and the closing arguments by the attorneys, I will have a stipulation to read to you. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that Patricia Byrd was not listed by the current or previous defense counsel as a potential witness in this case. Does each juror have a copy of the jury instructions in their seats? Please raise your hands. For the record, each juror has been provided with a copy of the instructions. I'm going to read these instructions out loud to you. You may follow along by reading as I read them out loud, or you may listen. The important thing is that you pay careful attention to the instruction on the law. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Donna Adelson, the defendant in this case, has been accused of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Donna Adelson is accused of first-degree murder in count 1 of the indictment. If you find Daniel Markell was killed by Donna Adelson, you must then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder. I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder. Count 1. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markell is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markell.
Yep.
An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing.
Are y'all convinced beyond a reasonable doubt?
Count
Let me know.
2. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1. The intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2. In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson or Catherine McBanois or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. Count 3. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1. Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder. Element 2. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder.
It looks like she did.
It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if she had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to, and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Daniel Markell occur. This instruction only applies to count 1 and 3 and does not apply to count 2. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all of the things the person who was promised or received the money did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur. And 2, she made or promised the payment in exchange for the commission or promise to commit the crime or to help commit the crime. And 3, the crime was committed by the other person. To be a principal, the defendant does not have to be present when the crime is committed. This instruction only applies to count 1 and 3 and does not apply to count 2. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt.
Exactly.
A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty? Was the witness present in the courtroom during the testimony of another witness or other witnesses? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness.
Here we go.
Check on what's happening in the hallway. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt,
I want to see if I can find the verdict form.
Must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. There is only one verdict form, which I am in possession of right now, but I will read to you all of the options that are available on the verdict form. State of Florida versus Donna Adelson, defendant, case number 2023 CF 3226. Verdict, count 1. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of first-degree murder. Letter option B. The defendant is not guilty as to count 1. Count 2. We, the jury, find as follows as to count 2 of the indictment: conspiracy to commit first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of conspiracy to commit first-degree murder. Letter option B. The defendant is not guilty as to count 2. Count 3. We, the jury, find as follows as the count 3 of the indictment: solicitation to commit first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of solicitation to commit first-degree murder. Letter option B. The defendant is not guilty as to count 3. And then the verdict form is to be signed and dated by the individual who will serve as the foreperson. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to proceed with its closing argument?
Yes, Your Honor. May it please the court.
Here we go. We're about to start the closing arguments. What do y'all think about those jury instructions? Seem pretty straightforward to me. Very easy to understand. Let me know what y'all think. And let's look at this poll in the chat real quick. So I asked you all, will Donna be found guilty on all counts, not guilty on all counts, guilty on 1 or 2 counts, or hung jury? And what do we have so far? It looks like a tie between not guilty on all counts and a hung jury. 7% of you feel like that's going to be the case. We have guilty on 1 or 2 counts. 37% of you think that might be the case. And then 48% of you say guilty on all counts. Pretty torn. And I think that's a fair point, because again, as the Honorable Judge Everett just reminded us, they don't have to prove her innocence. The state had to prove her guilt. In my opinion, and this is my official verdict, in my opinion, the state has proven Donna Adelson knew, was involved in, and in some ways helped follow through with this murder of Danny Martell. So I think it's going to be guilty on all counts. Rest in peace to Danny Martell. Sad, man. Jury, and they're about to deliberate. Yes. Where's the box that says she did it? Good morning to everybody just joining us. It seems a lot simpler than Karen Reed. Yes. Judge, Your Honor, sir, I was kind of upset when you wouldn't let us hear you reprimanding the attorneys. I agree. What's up with that, man? Why is he protecting them? Okay, let's go ahead. Here we go. We're finally going to get into closing arguments from the state. From the state. Get ready for some fireworks here. Here we go.
Influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to proceed with its closing argument?
Yes, Your Honor. May it please the court. Counsel.
She's got the red on because she's about to be on fire.
Morning. Well, this is Dan Markell. He's the victim in this case. A son, a brother, colleague, a mentor, a professor, a friend, but most of all, a father, an Abba, a dad. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his time with those little boys in the wake of a bitter divorce from their mother. Defense called witnesses to come in here and give you an expert opinion that his divorce and the subsequent litigation was not contentious. Not contentious to whom? It was contentious to Dan Markel. It was contentious to Wendy Adelson. And it was contentious to this defendant.
Oops.
And then after telling you what a great guy Dan Markel was in opening statements, they called witnesses to tell you what a pain in the butt he was. And he was a pain in the butt to those people, those awful lawyers that can't even admit that divorces are emotionally charged. He was a pain in their butts. He was a pain in Wendy's butt, and he was a pain in Donna's butt. Why? Because this was his life.
We got
were
to start
talking
the butt
about.
counter.
Dan Markel was not a file on some lawyer's desk. He was a real person who cared passionately about every scrap of paper in that divorce file. He wasn't some bumbling idiot. He was a Harvard-educated law professor. And yeah, he was making it as difficult as possible for this defendant to get her non-negotiable, which just also happened to be Dan Markel's non-negotiable, those two little boys. You have learned about this conspiracy and how it has unraveled over the last 11 years since Dan Markel's death. The defendants in this case have all attempted to point fingers at each other. They have argued that the state's theory is right. It's right. You got it right with everybody except for me. I didn't do it. Garcia's defense was that Charlie went directly to Rivera to arrange the hit on Dan Markel. Catherine Magbanua testified in her trial and said she had no knowledge of this murder. Charlie must have gone around her directly to Garcia. In Charlie's trial, he said Magbanua, Garcia, and Rivera all got together to kill Dan Markel without any direction from any Adelson family member. Each defendant characterized himself or herself as another victim in this case. A victim in this situation, a victim of their co-defendants, setting them up, or the appearance of evidence that seemed to implicate them but wasn't what it appeared to be. But despite their efforts to insulate themselves and to distance themselves from their co-conspirators, they made enough mistakes to get themselves caught and held accountable for their respective roles in this conspiracy. And today is Donna Adelson's turn. Despite their efforts to play victims, Dan Markel is still the only victim in this case. And the only thing he was guilty of was fighting like hell for those little boys. And he lost. He lost everything. This is what he looked like before. This defendant conspired to hire a hitman to have him killed, and this is what he looked like after. The evidence has shown that on July 18th, 2014, this brilliant, accomplished, beloved man was gunned down in cold blood in his own garage. This horrific death ultimately set the police down two separate paths, following the two most promising leads that they had. The first lead was to chase down that Prius that, thank God, Mr. Geiger caught a glimpse of pulling out of the driveway that morning. And the second path was to ask, as we would with any murder investigation, who had a motive to want him dead? And within 1 hour of the shooting, well before Professor Markel had even been pronounced dead, this path was already pointing to the defendant when Wendy Adelson revealed to officers that her parents had more reason to dislike her ex than anyone else. And what offense had Mr. Markel committed against Donna Adelson and her family? Refusing to let his children be taken away from him? Objecting to her telling his kids that he's stupid? The evidence has shown that Donna Adelson was all about psychological warfare. And when all else failed, she was willing to do whatever it took to accomplish her non-negotiable, to get a win. In order for you to render a verdict of guilty, the state must prove to you beyond a reasonable doubt that these crimes were committed and that this defendant is the person who committed the crimes, or in this case, one of the persons who committed the crimes. It is undisputed that these crimes were committed. This was a first-degree murder. No doubt about that. But who did it? The only issue left is identification, or what we call ID. The defense told you in openings motive doesn't really matter. Don't pay attention to all the motive. Don't pay attention to all the emails. But motive can be compelling proof of who done it. Identification. And thus critical to your determination of the defendant as one of the persons that committed this crime. Despite some of the testimony that you heard, it is clear that the divorce between Wendy and Dan was contentious. Except the person who cared most about Wendy's divorce, and relocation specifically, wasn't Wendy. It was her mother. Charlie Adelson solicited Catherine McBanoa to kill Dan Markel, but why? Who solicited Charlie? Because Charlie didn't care about the Adelson family getting a win against Dan Markel. He didn't care about relocation. He didn't care about Wendy's divorce. He cared about go-karts and jet skis and pretty girls. But he also cared about getting things done for the number one woman in his life, and that was his mother. She managed Charlie's life for him, and in return, he solved problems for her. That pattern is seen throughout this case. He talks to Wendy on the defendant's behalf to get her to pull the plug on the Tallahassee house, to date Dave and invite him to Mother's Day, to pursue a medical malpractice job, even though that's not even her area of the law. And on and on and on. She micromanaged Wendy's life. Charlie knows how to manage Wendy in a way that Donna can't, or knows how to talk to her in a way that Donna can't. And Wendy needs their help, right? Because according to them, she doesn't even have enough of a brain in her head to run her own life without their help. Donna decides what's best for everyone, and if she runs into any problems making that happen, Charlie is her go-to guy to get it done. He is the problem solver. And what was the biggest problem that Donna Adelson had in 2014? Dan Markel. Wendy filed her petition for divorce on September 10th of 2012, and the defendant was right in the middle of it. In the fall of 2012, the defendant told her son, Rob Adelson, that she had been in Tallahassee for several months, renting a new place for Wendy. She used her own maiden name to do that, to disguise the identity of who was renting it, arranging for movers, moving money around, and getting things set up for Wendy to leave Dan. Then Wendy calls Dan Markel and delivers the news that she's leaving him. How does she do it? She tells him she and the boys are moving out of the marital home, and the defendant gleefully, that was Rob's word, reported to Rob, her son, that she and Wendy strategically planned to deliver that news to Mr. Markel so that he would get this bomb dropped on him right as he's about to take the stage to deliver this lecture. According to Mr. Markel in one of his filings, quote, while the husband was away on a short business trip, the wife left the husband in the marital home, taking with her the children's furniture, clothing, toys, and whatever assets, both marital and non-marital, she desired. The evidence has shown that from the start, this defendant was very involved in managing Wendy's divorce. In October of 2012, defendant writes an email entitled, Things to Discuss at Your Mediation to Make Sure You Have in Writing for a Settlement, in which she refers to Wendy as a hostage and a prisoner in Tallahassee. That's what she believed. The email also includes the suggestion that Wendy pursue a restraining order against Dan Markel, that Wendy should go for 100% full custody of those two kids and relocation, and the threat of this conversion to Christianity. Quote, if he leaves you in Tallahassee, the children will not be attending Hebrew day school. That's not a threat, just a warning. A warning that her friend, Miss Cunningham, on the stand dismissed. Oh, that was just a foolish thing to say, right? But the characterization of these threats as, just something that was a one-off heat of passion thing has been completely destroyed by the evidence in this case, because she repeats it. She plans it with a lot of specificity. Wendy even admitted that her mom was serious about planning a baptism for these kids to change their religion as a ruse to try to strong-arm Dan Markel into giving up those kids. This is an example of the defendant operating with the emotional subterfuge as described by her daughter, Wendy Adelson. Also remember how her son Rob described her. She has rigid and fixed ideas of what she wants. And as long as you comply, things are fine. But when you don't comply, things are not fine. Wendy even admitted that if Dan had relented and moved to South Florida, or at least allowed her to move there, they might have co-parented happily ever after. But Dan did not comply, so things were definitely not fine. The defendant ends this email with, quote, we will help you in any way possible for you to come here. In October, this defendant drafted language for Wendy's petition to relocate, including allegations that Wendy had been upset about having to live in Tallahassee since 2005, and a mention of putting the boys in a Christian school and on a non-kosher diet. Again, that's not a threat, just a reality. And the suggestion that the boys live in South Florida with Wendy and Dan just fly back and forth to see his kids. He can just come see them every other weekend by airplane. Doesn't that sound like an amicable, equal time sharing that the lawyers for the defense described was going on here? Wendy's lawyer says she had no knowledge of Wendy's mom being involved in her divorce, but the evidence shows she absolutely was. Wendy sends the proposed petition for relocation from her lawyer to the defendant with a note that says, here it is, let's edit. And the defendant responds the next day with detailed feedback, including an argument that Dan Markel is incapable of taking care of his own children and that Wendy should seek 100% custody. Arguments which Wendy forwarded to her lawyer as her own. And upon receiving the lawyer's answer, she sends the lawyer's answer back to the defendant. That's in evidence. Defendant's thoughts about Wendy's earning potential and her work environment in Tallahassee. Arguments about she'd be better off with this other job that's higher paying in Miami. And defendant says she's been living in Tallahassee, that she, the defendant, has been living in Tallahassee since the petition was filed to help Wendy with the boys. In January of 2013, the defendant advises Wendy on her amended petition to relocate. And this is where the argument is raised about the job as a major bargaining chip in the divorce. The defendant writes here that Dan needs to know that there's no way in hell Wendy is going to stay at FSU. On January 14th, Wendy files an amended petition with request to relocate, which you can read and see. The petition contains many of the defendant's arguments. She couches this relocation in terms of not only important, but like a matter of life and death. Look at these quotes. It will create a major negative change in our lives. It will ruin your entire life. The rest of all our lives, mine, Dad's, and even Charlie's, will be affected by how well she can perform and act before July 31st to try to get this relocation thing turned around. Donna has even started pre-screening men for Wendy to date in the Miami area.
Which was weird.
In February, Dan files his response to Wendy's motion to relocate, alleging Wendy took his stuff when she left. The sole reason for relocation is to be close to her mother and family in South Florida, and that contrary to what Wendy put in her pleading, he was not seeking to leave FSU. He wasn't trying to move. Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense expert's ever seen, but pretty nasty. Dan Markel requests sole decision-making authority for these kids regarding education, medical, and religious matters. The defense lawyer witnesses said, oh, that was never going to work. Maybe that's true. But these were concerns that Dan Markel took seriously. There's tons of discussions in evidence in these binders before you, in the pleadings and in the emails about Dan Markel's desire to raise these boys in accordance with his faith and his concerns that his wishes were going to go right out the window as soon as the boys went over to be with Wendy or her mother. And defendant took this matter seriously too. She made it crystal clear in these emails that she had no respect for these boys' fathers' wishes for them regarding religious practices. In this email, defendant says she's sitting at Wendy's kitchen table working on Wendy's response to the filing we just talked about that Dan Markel made. So much for her having no involvement in her daughter's divorce. She says in this email to a friend, all Wendy wants out of this is to relocate to South Florida where she has us and Charlie. Danny is making it very difficult. On March 5th, 2013, defendant sends a long email in response to every paragraph of Dan Markel's arguments against relocation, including that Dan's religious practices are fanatical and dangerous to the boys, and that Dan Markel is psychologically unfit to have custody of his children. It's not sounding very amicable, is it? In opening statements, the defendant's attorney acknowledged that Dan Markel was an intelligent, accomplished professor and a dedicated father, and the state could not agree more. But the evidence has shown that her client didn't agree with that. Yep. Donna Adelson repeatedly paints Dan Markel as a self-important idiot who's not fit to care for his own children. On March 6, 2013, Dan Markel sends Wendy an email threatening to take her to court over her failure to cooperate with the Skype thing. That comes up repeatedly. Here he says, you've made zero efforts to facilitate that when you or your mother could have easily done so. I don't want conflict or tension. I desperately want peace and joy. Please let that happen, but do not mistake my politeness or desire for cooperation as a lack of firmness. I will not tolerate failures on your part to keep our agreements. They did have a Skype agreement, and she was violating it, and he was furious about it. This email was forwarded by
As he should have
Wendy
been.
to this defendant. So she knows about all this stuff. Dan Markel sent Wendy an email in December, which was pretty personal, and in which he is kind of a mea culpa. He apologizes for things that went wrong in the marriage and takes some accountability for what he views as his mistakes in the marriage. And Wendy forwards this email to her mother. Then
Weird.
Donna responds to this personal email and goes through Dan Markel's writings paragraph by paragraph, suggesting how Wendy can manipulate his words against him. Oh, look, he's admitting this here. This will help you in the divorce. And she does it in Wendy's voice. It's weird. Look at it.
It is weird.
So although sometimes Wendy seems to be complaining about her mom overstepping, you know, she's trampling my autonomy, it's like she's also inviting her
Enabling
mother
it.
into her business
Mm-hmm.
and wants her help. But also,
Yep.
don't trample my autonomy. In fact, Wendy thanked her mom for the thoughts that she gave on this letter Dan Markel wrote. She also wrote that she never would have left Dan Markel without her mom's support. In May of 2013, the defendant refers to one of Dan Markel's responses as a, quote, 23-page rant. Then she doubles down on relocation as the most important and non-negotiable part of Wendy's divorce. I mean, how many times does she have to tell y'all it's important, but somehow the defense is still, it wasn't important, or it was over. It didn't matter.
Mm-hmm.
She notes here that Dan Markel threatened Wendy with federal kidnapping charges. He threatened her daughter with federal kidnapping charges for taking those kids without telling him where she was going when she left. The defendant signs off, "I'm too angry to write anymore." And the evidence has shown that this nice, normal, sweet little grandma certainly was angry. To support the argument that Wendy should be able to relocate because Dan was always traveling on work trips, the defendant sends Wendy this email. And it contains every date, like the date ranges that Dan Markel has been out of town traveling for work since the birth of their first child. That's 4 years. She is able to go back and send to Wendy, he was out of town this date to this date, this date to this date. It's a little shocking that she recorded that information, but we know she is a very detailed person. She keeps these extremely detailed day planners. But Dan Markel's travel schedule is of particular interest, in fact, in light of the fact that the hitmen knew that Dan Markel had to be killed on July 18th because he was going out of town the next day. The question is how'd they get that information? Who had that information? Then the next day, Dan Markel files a memo of law asking for the attorney's fees and saying that, quote, if costs are not awarded, then the wife and her affluent parents who are bankrolling the wife's litigation so they can enjoy closer access to the grandchildren will persist in vexatious and groundless litigation. Dan Markel knew that Wendy's parents and their considerable resources were a big part of why this divorce litigation was dragging on.
And he was right.
They thought he was filing frivolous stuff to drag out the divorce and the proceedings, and he thought the same thing about them. On June 21st, the court issued the order denying relocation. When Wendy was on the stand, the defense made a big deal out of, oh, you didn't tell mom it was final, did you? You stipulated to it, didn't you? Which we later learned was because the judge had already ruled at sidebar that it wasn't going to happen. But basically, you know, you kept your poor mom in the dark and she thought this was still something that was viable and you didn't tell her it wasn't. But on redirect, it was proven that that was not true. Defendant did know that the order was final and she expressed this in an email to her friends. Poor mom wasn't kept in the dark on anything in this family. In fact, the defendant recognized perfectly well that this order meant she wasn't going to get relocation through the courts. She wasn't going to get what she wanted through the legal system, but that wasn't the only way to skin a cat, was it? She wasn't deterred by a loss in court. Instead, she started looking into other options to get a win for the Adelson family. There was testimony offered that everyone knew that there was a slim chance of Wendy winning relocation. Maybe everyone knew that on the lawyer's side, but the defendant didn't know that. She was not happy about this loss in court. Here she laments, unfortunately, after paying a lawyer $600 an hour for 10 months case preparation, the judge listened to Wendy for 1 hour and made up her mind. Outrageous. So at the moment, we will not be allowed to relocate. Note the phrase "at the moment." Jibbers had not beaten the Adelson family yet. Defendant concludes this email, anyway, if I sound angry, it's because I am. We're all very upset and cannot believe the outcome. She couldn't believe relocation was denied. When Wendy expresses defeat over the court's order, the defendant isn't having it. She encourages Wendy to never, never, never give up, to take control, to not let Jibbers think he's won anything by having you remain in Tallahassee, and to show this fucker what will make him absolutely miserable.
Dang.
Hey, yo.
How amicable.
Watch your mouth, Donna.
Then defendant solicits Wendy to put on the performance of her life because Jibbers hadn't beaten the Adelson family yet. And this is where defendant reveals her plan of action, including having her Jewish grandsons baptized and offering $1 million to Dan Markel to facilitate this relocation. Control is a theme that's featured prominently throughout this email and throughout this case. There is evidence that the defendant controlled Wendy, she controlled Harvey, and she controlled Charlie. But she could not control Dan Markel.
Nope.
He wasn't going to give her a win. As long as you went along with her rigid, fixed ideas, things were fine. But if you didn't, things were not fine. Defendant continues to react to relocation being denied and Wendy's inclination to give up on the matter, including, everyone has a price. Now is the time to start. You said this divorce is not about winning and losing, and it's not a competition. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family, teaching in Tallahassee. Life is tough. If you don't stand up and take a chance, you don't stand a chance. Please, Wendy, do your part and stand up to him. Make an effort to do this so that our group offer will stand a better chance of being accepted. Don't let this temporary move to Tallahassee ruin your entire life. Fight for yourself, Wendy. We'll be there to help you. Just don't tell us that what you need to do is move forward with a sense of peace. Can't have that, can we? That's giving up. Giving up on relocation was not
Don't
an
let him
option
win.
for Donna Adelson.
Wow.
Neither was losing. Throughout the trial, the defense tried to distance themselves from these emails. One of the ways they did that was by trying to put him off on Harvey. They pointed out, hey, this is a joint email account. One of these is signed Mom and Dad. And there's a few that are signed Mom and Dad, but it's clear that the defendant is the author of these emails and that she's the one driving the bus on this relocation effort. And during the presentation, we highlight all the dad and I language, all the indications in there that Donna is the author as opposed to Harvey being the author. According to her own daughter, Wendy, she's the dominant force in that household. And according to her son, Rob, she is a controlling person as opposed to the more passive, go with the flow type of personality that the dad, Harvey, has.
Yep.
In opening, the defense attorney told you that this defendant was a normal person, and you don't have to decide she's not a normal person. You're the judge of the facts, right? Was a crime committed? Is this the person that committed the crime? But in this email, she suggests that dressing her Jewish grandchildren up in Hitler Youth uniforms would be acceptable. That would accomplish her goals. The ends justify the means for her, people.
Mm-hmm.
That is illustrated here, and it sums up this entire case. The defendant wanted this done because that was the only way left to get a win. If he had submitted, if he'd let her take those kids, he'd be alive.
Maybe.
He moved to South Florida himself, he'd be alive. But he would not submit. She could not get that win. He was a huge problem, and she made it Charlie's problem. To Charlie, who liked the idea of being a tough guy, who had connections to people on the wrong side of the tracks, the price of Dan Markel's life was worth the reward of pleasing his mother and easing her diarrhea and getting her to finally shut up about Wendy's divorce. In the
Dang.
mind of this defendant, all their lives depended on the success of this relocation effort. She tells you as much herself in these emails. Listen to her. And as such, any and all means were justified. Because not everything one has to do in life is comfortable or easy. Sometimes it's ridiculously hard. This is what passes for normal in this family. I said the defendant made Wendy's divorce Charlie's problem, and the evidence shows that the defendant did keep Charlie in the loop every step of the way. Here's a July 10th email that states, just to catch you up on what's happening with Wendy, and discusses who should be involved in the bribe that the family wants to offer to Dan Markel. On July 19th, the defendant requests, and Wendy sends her copies of the motions, responses, orders, and transcripts from her divorce so far. That same day, Dan Markel makes a settlement offer that this defendant encourages Wendy to reject, saying the answer is no to all of this. Please, Wendy, we've been with you from day one. Do not accept or sign anything without the two of us reviewing and discussing all of this with you. Screwing him financially is what will aggravate him. But ultimately a settlement
Why?
is reached. Y'all have heard about this date, July 31st, 2013. But contrary to what the defense has told you, the fighting did continue. On October 12th of 2013, 3 months after the divorce was final, the defendant forwards an email to Charlie Adelson, which Dan Markel had sent Wendy. And the defendant adds the note, "This is what this fucker is sending your sister on a regular basis. He is absolutely crazy. Impossible." Does it sound like everything was over?
Doesn't sound like a sweet
Was
old
an
lady
amicable
either.
divorce over? Not contentious at all, right? This is fall of 2013, the same time frame in which Wendy starts dating Jeff Lacoste and Charlie starts dating Catherine Magbanua. On October 13th, 2013, the defendant texts Charlie Adelson, quote, "Horrible evening for your sister." The pattern of this defendant getting worked up about Wendy's divorce and then forwarding it on to Charlie is seen over and over again. Which brings us to Halloween 2013. Several important events in the case occur on Halloween 2013. One, Wendy officially takes Dan Markel back to court, filing her motion to enforce the marital settlement agreement. So she's alleging he violated it, and she's asking to hold him in contempt of court, alleging that he's not paid the agreed upon fees that he was supposed to pay by a certain deadline. Wendy backs out of the contract that she had signed to buy a house in Tallahassee on Halloween 2013. Charlie later brags to the defendant that he talked Wendy out of buying the house, and the defendant calls him a miracle worker for having convinced Wendy not to buy the house in Tallahassee. Also, Charlie meets up with Catherine Magbanua on Lincoln Road on Halloween 2013, the same day Wendy pulled the plug on the house, and broaches the subject with her for the first time of, "Hey, do you know anybody that I could hire to harm someone?" And she did. Charlie sends this picture of himself and Catherine Magbanua together to Wendy that night, October 31st, 2013. First night, he solicited Catherine Magbanua to be a part of a murder, or a part of what would become a murder. Mid-November, Jeff Lacoste meets the defendant for the first time. Remember Jeff? He was Wendy's boyfriend that testified.
Poor Jeff,
Said
man. He
would
got played.
meet her 6 to 7 other times in addition to that first time during the course of his relationship with Wendy. Sometimes just in passing, picking Wendy up for a date. Other times more substantially, including taking the boys to the circus. And that becomes maybe important later. Meanwhile, the fighting continues into December. We're in December of 2013 by now. On December 16th, Dan Markel emails Wendy and the parenting coordinator that was assigned to help them try to navigate these issues about the defendant, Donna Adelson, disparaging him to his kids. In this email, he introduces what he calls a major issue. The headline on this concern is not buried, guys. Like he says, I'm introducing a major issue. He very plainly gives a preview of the grandma motion, which will ultimately be filed in March of the next year. And here he says that on November 8th, one of the boys announced at a Markel family dinner that grandma, referring to this defendant, says you're stupid. Grandma says you're stupid. Then the following Monday, on November 11th, when Dan Markel was buckling the boys in at the park, they both tell him that grandma says you're stupid. When asked why, they say because you're trying to take her sunshines away from her. When asked who are her sunshines, the boys answer they are her sunshines. Then again on November 30th, while playing with the older child, that child repeated the statements to Dan Markel, grandma says you're stupid. And again when asked why, the child repeated that the defendant said that Dan Markel was stupid because he was trying to take grandma's sunshines away from her. Markel implores Wendy to address the situation, as he would like to avoid a hearing in which his kids are going to be primary witnesses against their grandmother. He assures her that he will, though, if necessary, seek judicial relief that prevents contact between the children and their grandmother. This lawyer that testified said, "Oh, that wasn't going to work." Well, he didn't think so. "Oh, well, that's no big deal. I've seen much worse than that in my career." Well, yeah, Dan Markel hadn't seen much worse than that. Dan Markel had a big problem with grandma saying he was stupid, and he wanted to take it up and address it with the judge if necessary. Dan Markel emphasizes that this is a matter he takes very seriously and says that the defendant's actions could lead to the termination of Wendy's parental rights. Is that true or not? Doesn't matter. He thought it was true, he threatened it. And those are fighting words. Going to terminate your parental rights? Wendy forwards the email to the defendant the next day, December 17th. And what's the response? Wow. That's a response we see from the defendant quite a bit. She's usually more verbose, that's true. But why is the defense working so hard to say that their client didn't see this email and didn't know about these allegations? I mean, isn't it clear that Wendy is sharing all the issues relating to her divorce with her mother? Wendy communicated with her mother on all these filings, and this one pertained directly to her mother. Of course they discussed it. Are you really to conclude that nobody was fighting anymore prior to Dan Markel's murder when the evidence leads you to conclude the exact opposite? This was a pressure cooker, and it was being turned up hotter and hotter with each passing day. Not only is this a situation that's escalating between the actual parties to the litigation, but now the defendant has moved from working behind the scenes, helping Wendy with the divorce, to actually being the subject of the pleadings that are before the court. There was supposed to be a hearing on that issue. One thing Dan Markel wrote in this email is, quote, "I fear that the children's best interests are not being pursued so much as what grandma wants." If he only knew how legitimate that fear really was. Those weren't just some ugly, foul words thrown around in the heat of the moment, folks. They continued well past the finalization of the divorce. Here on January 10th, 2014, so now we're in the year where Dan Markel is killed. 6 months after the divorce is final, defendant says of Dan Markel, wow, is he on drugs? Is he also going to pay $70K plus the legal fees and interest that bastard owes you? So the bad blood is going strong here 6 months before the murder, and the divorce wasn't really final anyway, in the sense that we're continuing to have pleadings get filed back and forth. In February of 2014, Dan Markel emails Wendy threatening to file motions, exposing her for what he said was hiding assets, $200,000 worth of assets from the court, and giving false testimony under oath. And also to accuse her attorney of misconduct.
It's not good.
Lawyer witnesses say none of that's a big deal, none of that was going to be successful, but he thought it was going to be successful. To him, it's a lot of money. To him, it's a big deal. The next day, on February 15th, 2014, we see a text from the defendant to Charlie. Wendy's totally stressed out. Yesterday was a rough one. She will probably have to go through another depot. Outrageous. Rob Adelson testified that his mother told him they were, quote, depoting Wendy to death. But then their expert witness got up there and said Wendy was never deposed. I guess they didn't provide her with that information, or any of these emails or text messages post July 31st, because this thing was not over on July 31st. In this text, defendant accuses Dan Markel of stalking Wendy, and Charlie agrees. The defendant tells Charlie to keep the conversation with Wendy light and don't bring up the divorce drama, which kind of implies there was divorce drama going on. There's a sense in this email and elsewhere in the evidence that defendant and Charlie have to tiptoe around Wendy, like she's this damsel in distress that needs the two of them to step in and help her handle her business.
Dan
February
needed help.
17th, 2024, defendant again reports to Charlie how Wendy's hearing went and talks about how there are plans to seek to have Dan Markel forced to submit to psychological testing. Here, defendant is 7 months after the divorce and just 5 months before the murder, responding to Dan Markel's filing a request to produce, and she says it's time to give it to him. Let's aggravate him the way he's trying to aggravate you. And what can your attorney do to be proactive to give him some grief? Can't you meet with her and work out a plan of attack? Something has to be done with this asshole. This is 5 months before the murder. Here, defendant texts Charlie about Wendy yet again. If you speak to Wendy today, tread lightly. Don't ask questions about the depot, her lawyer, etc. Tough time, and she's really stressed out. The asshole showed up at soccer yesterday, and she goes into a story about, he showed up at soccer and they got into it. And then she ends with such a fucker.
Jeez.
Super amicable. Then we have this text on March 4th.
I love
gears.
the sarcasm.
This is about the birthday gift. Defendant texts Charlie that she's going to call him from the bathroom in Gainesville where she can have some privacy. Please pick up because I will have very limited alone time today. Erase this text after you read it. Then the defendant says we'll speak privately about Dad's birthday gift. So erase after reading. You might think, well, maybe she was just trying to keep the birthday gift a surprise, but why does Charlie need to erase it? Harvey's not with Charlie, Harvey's with Donna. And according to Rob, there were no birthday gifts for Harvey, unless the murder was supposed to be the birthday gift. Plus, in the text, Donna wants Charlie to delete after reading the text that doesn't mention the birthday. She doesn't say anything about deleting the one that does mention the birthday. Rob Adelson was present at the birthday party, which did take place between the 2 trips that the hitmen took to Tallahassee. And there were no birthday gifts, according to him. The defense suggests that the friends coming to the party was part of the surprise, but then they also suggest that Harvey sent the Evite, so I don't think they can have it both ways. He can't send the invitations and be surprised by the friends. The next week, Jeff Lacasse, Wendy Adelson, Catherine Magbanua, and Charlie Adelson all go out to dinner. That's the first meeting between Wendy and Jeff and Catherine Magbanua. At dinner, Magbanua mentions her ex having several run-ins with law enforcement. That stuck out to Mr. Lacasse. After dinner in the hot tub, Charlie bragged about having connections to people on the wrong side of the tracks. Notable in the same time frame, March 21st, 2014, the defendant signs a lease on a condo in South Beach, a condo where Wendy, after Dan's killed, would move in with her kids. They say, oh, that was a weekend place, so it's pretty convenient timing. You just happen to get this other house and have it set up for Wendy to move into after her ex-husband's murdered, and she's able to relocate. 3/26/14, this is when Dan Markel officially files the grandma motion, which takes aim at the defendant, raising more allegations about failure to comply with the Skype thing, Wendy leaving the boys with her parents rather than giving him the right of first refusal. And he says by flouting the right of first refusal, the former wife creates conditions for Mr. Markel to be disparaged in the presence of the children by their maternal grandmother. Dan Markel then alleges all the same allegations about the defendant disparaging him to the kids that he outlined in that previous email in December. Contrary to what the defense said in court, in his prayer for relief, the remedy Markel was seeking was to have the court order this defendant to have no contact with those boys unless she was supervised, because he didn't want her disparaging him to the boys, and because it was a violation of the right of first refusal, in his opinion, for Wendy to leave the boys all the time with her mom and not give him a chance to have them if Wendy wasn't going to keep them. How do you think Donna took this information? She refers to those kids as hers. She was the one sacrificing her time at the office to be up here in Tallahassee doing for those boys. She had invested so much of her own time in this fight against Dan Markel to try to get a win for the family. And after all that investment in those kids and all the money spent on the attorneys and all that time spent at the kitchen table working on those divorce filings, Donna Adelson was losing. The boys and Wendy were stuck in Tallahassee. Wendy wasn't working at the law firm in South Florida, raking in a bunch of money and dating some new guy that she pre-screened for her. And Grandma's Sunshines weren't in South Florida. That's where they belonged. That's what was best for them. They had lost in court. Wendy wouldn't comply with Donna's plan of action, and Dan Markel apparently wouldn't take a bribe or be strong-armed to allow his kids to come to South Florida. But, as it turns out, Gibbers still had not beaten the Adelson family, because there was still another option, the option of hiring the hitman. Charlie joked about hiring a hitman, but he had also been actively pursuing that option at least since Halloween of 2013. Over the last several months, Charlie had several conversations with Catherine Magbanua about this job, which started as a request to harm and then eventually revealed itself as a murder for hire. Recall that Magbanua said that often when she and Charlie would discuss the murder and the pressing need to get it done, he would emphasize to her that the toll that Wendy's situation was taking on his parents emotionally and physically as they were stressed to the point of being physically ill. So he would often tell her that's the motive. That's why we need to get this done. It's like stressing out my mom. On May 16, 2014, 2 months before the murder, Wendy was added as a resident to that condo in South Florida. On May 30th, 2014, Donna sends Charlie the text, quote, "Horrible morning with Danny. Tough conversation with her." This text was sent less than 2 months before the murder. The drama is continuing. Everyone's still fighting. It's contentious. Prior to the June trip, Charlie had prepared an envelope containing the murder instructions. He told Catherine Magbanua that he used gloves when handling the paperwork inside.
Charlie was
printed it, not
dumb.
on any printer that can be connected to him, and that she was not to touch the contents of what was inside. She was to deliver the envelope to Sigfredo Garcia. She followed these instructions. In early June, she came back to Charlie asking for travel expenses for the hitmen. She got a couple $100 to give them to rent a car to come up here. They came, well, let's back up just a little bit. They rented the car June 2nd, 2014. Magbanua drops Garcia off at the rental car place, and then Magbanua calls Charlie on the way home from the rental car place. And you saw the evidence of this in Sergeant Corbett's presentation. Charlie immediately calls Donna on the landline after hanging up with Magbanua. How do we know that he talked to his mother and not his dad, since it was the landline? Well, because a few minutes after that call, he talks to dad on his cell. So probably didn't talk to dad on the landline, and then a few minutes later talked to him on the cell. Garcia and Rivera travel to Tallahassee. This is June 4th, 2014. Rivera notes that Garcia is in possession of a piece of paper. The paper has a photo on it and some information. This information allowed them to locate and follow Dan Markel's vehicle, a black Honda Accord with the tag number 534YBM. Information that the defendant had written in her 2014 planner. Wendy and Jeff Lacoste have their coffee date, at which she cancels their planned trip to California on July 11th through the 17th. She offers no real explanation for why she's canceling, except to say that she's real worried about being able to pick up the boys on the 18th. The 18th, of course, ends up being the day that Dan Markel is killed.
Wow.
Later that night, Jeff Lacoste goes to Wendy's, and she's a nervous wreck. She won't tell him what's wrong, but her stomach's upset, and he goes and gets her Pepto-Bismol. The killers are in town when that happens. The
What a
hitmen
guy
spend a day
Jeff
and a half
is.
following Dan Markel around Tallahassee. Here they are near the park there by his residence. They scope out his residence, and although Rivera had already purchased the murder weapon, a revolver that he got on the streets for the express purpose of killing Dan Markel,
Look at
they
that poor
lost
lady
him, or he was
sleeping
with the
back
kids,
there.
or for whatever reason they did not get the job completed on the June trip. After the hitmen failed to get the job done, Charlie tells Donna on June 7th of 2014 that he's still working on Dad's birthday present, and she says, "I know you'll come through." Sometime around June 11th, Jeff Lacoste went over to Wendy's residence and observed her living room TV to have some impact damage. This was the same TV that Charlie got Wendy as a divorce present because it was cheaper than hiring a hitman. The location and damage to the set did not appear consistent with something the kids could have caused, at least to Jeff. Note that this is over a month before the murder that Jeff observes this damage, so it was hung out there for a while. June 13th, the defendant has a note in her calendar to consider canceling Harvey's birthday party if that's what he wants to do. Now, this is between the June and July trips, that there's a note to herself to talk to Harvey about whether or not he wants to cancel the party. Rob Adelson testified that there was no illness or anything going on in the family that he knew of that would potentially result in the canceling of Dad's party. This note may be contemplating that if the murder had happened on the June trip, that Harvey might decide it's not appropriate to go through with the party and we need to cancel these invitations. Wendy took a photo with Catherine Magbanua on the beach 2 days after that note to self in the planner. Here she is in front of the South Beach condo, pictured with Catherine Magbanua. That photo was taken June 15th of 2014. Wendy sends Rob a text with a picture of her and Jeff Lacoste. This is June 28th of 2014. She includes a request to her brother Rob not to tell her parents about her relationship with Jeff. This suggestion of a secret boyfriend later prompted Rob to suggest Jeff as a potential suspect to the FBI, a secret boyfriend. This was also a little odd that she sent this because Wendy never talked to Rob about her boyfriends, and also because Jeff had already met her parents several times.
Lies.
June 30th of 2014, the defendant comes and gets Wendy and the boys from Tallahassee to take them down to Miami. Remember how she doesn't let Wendy drive with the boys to Miami. She rents a car and comes here and picks them up and drives them to Miami herself. And I think Harvey comes with her. And Wendy was to be in South Florida for 2 weeks. In the time between the June and the July trip, Charlie begins to put more pressure on Catherine Magbanua to get the murder done. On several occasions when he and Magbanua were discussing the murder, Charlie would step out of the room to call his mother and then return and advise her that the murder needed to get done as soon as possible because his parents were so stressed and worried about Wendy's situation. Charlie painted Dan Markel as an awful person to Catherine Magbanua. He was making Wendy's life hell. He was stressing out her parents. Katie knew somebody who could get this thing done, and he wanted it done. Magbanua understood that the murder was needed urgently to relieve the stress on Charlie's mother. July 1st, 2014, we have a single call from Garcia to Harvey Adelson. This call did not connect. Appears like it went to voicemail. And we would later learn from Magbanua that this was after an incident in which her two love interests, Charlie Adelson and Sigfredo Garcia, had a little bit of a run-in. Garcia was angry and jealous about Magbanua dating Charlie and tried to confront Charlie. After this attempted confrontation, it's believed that Garcia was trying to call Charlie, but ended up getting Harvey. And that was that one hang-up call, but it ended up being important because it showed up on the tower dump, Garcia's number, and then when we cross-referenced it with all the Adelson numbers, that was the first match that gave us Sigfredo Garcia's name. We would later learn that the real connection between the Adelsons and the killers was Catherine Magbanua and her relationship with Charlie Adelson. The text messages found in Charlie's iCloud corroborate what Magbanua says about the interactions and the call made the day before. So here she's saying, basically, Garcia's being ridiculous and childish. Harvey's birthday Evite goes out on July 3rd of 2014. The Evite addresses the boys by the last name Adelson. Their name was Markel. This is 2 weeks before the murder of Dan Markel. Even though the Evite says hosted by Donna and the party was for Harvey, the defense has suggested that it was Harvey and not Donna that sent the Evites. The evidence showed otherwise, and Corbett told you there was some follow-up from Donna with the Evite people. She sent that email. A text is sent from Wendy's phone to Dan Markel on July 6th of 2014. At the time this text was sent, the phone was present at the South Beach condo where the defendant lived. Dan Markel confirms, yes, I'm going to be in town to get murdered, not specifically, but he's asked, are you going to be in town July 14th or the 18th? Those are the dates the killers were here. And this, despite the fact that the schedule for that week had already been decided way before this text. And Wendy was already scheduled to have the boys on that Wednesday, which is what she's asking about. She doesn't ask about the whole week that he's got the kids. She only asks about the 14th through the 18th. And I think the killers ended up going to Tallahassee on the 15th through the 18th. Obviously, Dan Markel was killed on the 18th. July 11th, 2014, the defendant comes back to Tallahassee to bring Wendy and the boys home. Okay, so bringing her home from the Harvey birthday party. That same day, both Harvey Adelson and the defendant separately, 8 minutes apart, email Wendy Adelson about her TV repair appointment that's going to happen on the day of the murder. July 13th, Wendy and Lacasse meet at Wendy's house, and she's an emotional wreck again for no apparent reason. Lacasse impeached her regarding some statements that she made during a discussion of their relationship that evening in the context of, you know, you got to get past this moving to Miami thing. I mean, you're not going to be able to move to Miami. And she says, you know, yeah, it's not an issue unless something happens to Dan. And she says, can I tell you something in confidence? And she makes the chilling statement at that time that her brother, besides joking about hiring a hitman because it was buying a TV because it was cheaper than hiring a hitman, he also, in fact, had looked into hiring a hitman to kill Dan Markel. This conversation occurred just 5 days before the murder. July 15th, the Prius is rented. July 16th, Rivera and Garcia traveled to Tallahassee. July 17th, Rivera and Garcia followed Dan Markel around Tallahassee. July 18th, murder day. You guys okay? Anybody need a break? Okay. July 18th. 8:11 a.m. The defendant texts
That was
Wendy
nice of her to ask during closing. I think I've ever seen that.
The TV repair appointment was planned for between 8 a.m. and noon that day. And she says they are on their way over now to help you with the TV sets in your living room.
Alibi, alibi, alibi.
Didn't know which TV set it was. This is the TV that Charlie bought as a divorce present because it's cheaper than hiring a hitman. Could it be a coincidence that this TV is also the alibi for Wendy on the day of the murder? While he's being murdered by a hitman?
I have no doubt.
And then, as we know, the defendant later uses TV as code when she's speaking on those wiretap calls. 8:20 a.m., Wendy texts Charlie, "This is so sweet. We don't know what it means." But she's texted him that, and then she deleted it. Sometime between the time it was sent, 8:20 a.m., and the time that her phone was cell-brighted or downloaded at the police station later that day.
Dang.
9:04 a.m., Dan Markel leaves a voicemail for Wendy telling her he's headed to the gym and wants to know if it's okay for him to pick up the boys early and take them swimming that afternoon. Wendy says no, he cannot take the boys swimming after school that day. Meanwhile, what's going on across town? The Prius is following Dan Markel into the gym parking lot. There it is at 9:16 a.m.
Just trying to be a
9:19
dad.
a.m. to
Jeez.
9:37 a.m. Charlie and Wendy talk for 18 minutes. Wendy and Dan argue back and forth a bit about him wanting to take the boys swimming, but after getting off the phone with Charlie, Wendy concedes the argument with Dan and says, okay, you can pick them up and bring them back to me when you're done swimming. But of course the swimming plan didn't happen because Dan Markel was killed. 10:38 a.m. the Prius follows Mr. Markel out of the gym
Nasty.
parking lot. 10:45 a.m. Mr. Markel is shot twice in the head, in his vehicle, in his garage. 10:51 the Prius is captured fleeing the scene on a city bus camera. 11:01 Mr. Geiger calls 911. 11:15 law enforcement arrives at the scene and sets up a perimeter.
Wow.
Dan Markel is rushed to the hospital. He's treated, but the damage is catastrophic. It's not survivable. And he passes away about 14 hours later. 12:30, the hitmen, now headed back south, turn their phones on. They had turned them off for the homicide. They turn them back on. The first phone call that either one of them makes is Sigfredo Garcia to Catherine Magbanua. They want their money.
Garbage.
Where's Magbanua getting money? From Charlie. 12:45, so while the killers are calling Magbanua and heading south, Wendy goes out of her way to visit the crime scene, encounters a roadblock and crime scene tape. Per the officer at the roadblock, she would have been able to clearly see the police activity at her former residence. The residence where her children currently lived half the time and where they woke up that morning. Yet she abruptly turns around and leaves. She does not make contact with the officer to ask what's going on. She does not call the police to inquire. She does not call Dan Markel to say, are you okay? There's a bunch of cops at the house. She does not call the daycare to make sure her children arrive that morning and are okay. Instead, she proceeds to the ABC Liquors, purchases her Bullet Bourbon at 12:49. She's later approached by law enforcement at lunch and gives a law enforcement interview in which she says, my parents have more reason to dislike Danny than almost anyone else. This echoes Rob Adelson's testimony that his mother hated Dan Markel at the time of his murder. And even from the periphery, it was known to Ryan Fitzpatrick as Charlie's friend that his mother did not like Dan Markel. In her law enforcement interview, Wendy suggests her mother as someone who was very angry at Dan Markel. She suggests Charlie when asked if someone might do this on her behalf. She calls her mom, and the defense has put that call into evidence. 7:04 p.m., she tells her mom that there's been a shooting, and afterwards, Wendy expresses relief that they sounded surprised. 8:59, defendant arrives at Charlie's with the murder money. How do we know she went there and that they aren't just old people that drive really slow? Well, there's a text message outside your house. I guess we're going to find out what that means, but I guess it's not going to be outside your house.
Nope.
And he says 10 men. Guess we're going to find out what that means, but apparently it doesn't mean I'll be there in 10 minutes and meet you there and get the money. About 10 o'clock, Catherine Magbanua joins Charlie at the house. Here they are making plans for that meeting. Next slide, please. Charlie answers the door with a gun in his hand. He's extremely amped up. He tells Magbanua, my parents just left. They both end up taking Xanax and sleeping over there for the night. The next morning, July 19th, 2014. So this is early morning hours, 1:25 a.m. I think we need the next slide. Yeah, 1:25 a.m. Donna and Harvey arrive at their Orlando hotel. In the morning, Charlie puts the money in Catherine Magbanua's trunk. She's seen at 9:33 a.m. approximately, heading south toward Rivera's house, where she's going to meet up ultimately with Rivera and Garcia and give them the money. Garcia takes the money out of the trunk where Charlie Adelson put it and divides it up between the three of them. Magbanua says she did not count her cut, but we know she put some of it in the bank, creating the largest monthly cash spike of any of the records we examined for her bank.
Now we know
This
why.
cash spike also occurs at a time when Magbanua was not employed.
And Donna was
Rivera
writing
says
checks
his
too.
understanding was the job paid $100,000 total to be split between the three, and that the cut that he received was roughly a third of that at $35,000. We don't know the amount of Garcia's cut, but we know he got at least enough to buy a car and a motorcycle. All right, so July 20th, the defendant and Harvey Adelson take Wendy and the boys back to South Florida. 2 days after, not even 48 hours after Dan Markell is shot. They're gone. Relocation granted. On the way, Wendy receives a call from Detective Isom. She tells him the call's breaking up, and she hangs up, afterwards referring him to her lawyer. Catherine Magbanua that day, or thereabouts, opens her Ziploc bag of money and finds her cut to be $100 bills stapled together in $1,000 stacks. How we know Charlie keeps his money. She also notes that her cut is damp and moldy. She mentions this to Charlie, and he tells her that his mother washed the money. Like laundered, like washed. Rob Adelson gets a call from Donna Adelson
That part's
advising him
crazy.
not to talk to the FBI. What? Rob Adelson gets a call from this defendant advising him not to talk to the FBI, just in case they call. He says,
Yeah,
"Well, I
by
already
the
did."
way,
She says, "Well, you don't know anything anyway," and hangs up.
jeez, man.
July 24th, 2014, Dan Markell was laid to rest in Canada. His children were not in attendance. August of 2014, the defendant registers the older child for flag football under the last name Adelson. His name is Markell. This is 1 month after their father was killed, and already he's being erased from their lives. Within 1 year, their names would be legally changed to Adelson. 9/12 of 14. The defendant refers to the younger child by the last name Adelson. 9/17 of 14. The first check is written to Catherine Magbanua, signed by this defendant. This is the murder money.
Donna's like,
Even though
dang.
Charlie has signing authority on this account, he could write these checks. He chooses to connect his elderly mother to a murder payment? If she wasn't involved, there is no reason in the world why she would write these checks. The defense said in opening that Charlie told Donna to write the checks because it was his business. But half of these checks were written after the business was sold back to Harvey on October 2nd, 2015. Regardless of who owned the business,
Rule members of the jury, you are relying on your memory of the evidence in this case. You may proceed.
thank you, Judge, and regardless of who owned the business at the time, all the Adelsons had an interest in the Adelson Institute. All three of them had signing authority on that checkbook. But the defendant is the one that wrote that check. September 17, 2014, and the 43 checks that followed. Is that consistent with what we've heard? That she would just write the checks and not ask any questions? We've heard that she is assertive, she's controlling, she's a details person. She ran that business and those people's lives. She ran a tight ship. We've seen her weekly planners where she plans out every detail of her own life, making meticulous notes. She kept detailed information about Dan Markell and lots of other things. Rob Adelson testified that she's not the
And she
type of
told her
person
mom.
who's just going to do something someone tells her to do. She's going to be asking questions. And we heard that Charlie testified that he told his mother about extortion. He says he was being extorted, right? All right, let's fast forward to October of 2015. Charlie's had a couple girlfriends since the murder and is now dating June Mchinda. Remember her? June, one of Charlie's girlfriends that testified, she said they were
Junko.
enjoying a fairy tale relationship in October of 15. During her relationship with Charlie, June observes that Charlie packages his money in an unusual way. $100 bills stapled into $1,000 stacks. June also observes the defendant to be in control of the family and super involved with the grandchildren. However, she found it odd that nobody in the family seemed curious about who killed Dan Markell, nor did they seem upset about the murder. Rob
Why would they be?
Adelson also noted a complete lack of curiosity on the part of his mother about this murder in the family. When he asked what the defendant thought happened to Danny, she said, quote, "I don't know and I don't care. It doesn't concern me." As someone who liked details and who always stayed on top of everything, her total lack of interest in who killed her former son-in-law, her grandchildren's father, is totally out of character.
Yeah,
From
since she
July
was
of
guilty.
14 to April of 16, Donna Adelson got everything she wanted. Wendy and the kids were in South Florida where she could drop them off and pick them up, manage their schoolwork, their tennis, their piano lessons, and have her sunshines with her every day. All the while, she's steady paying for the murder of their father.
Yep.
Everyone is living their best life, thinking they've gotten away with murder until the bump. Everything changed on April 19th, 2016, when the bump occurred. The undercover approaches Donna and hands her a piece of paper. The most human reaction in the world is to look at the paper. Uh-oh.
Somebody have to go to the
I think
bathroom.
we got one more. There we go. The defense told you in opening that this defendant is a normal person just like you and me. There is nothing normal about the way she conducts herself in the minutes, hours, and days after the undercover approaches her with that paper. The bump and the wire were designed to expose the co-conspirators and their roles in this conspiracy, and it did. Here, we're just 10 minutes later. There's only one thing a normal person would do if approached on the street by a stranger who appears to be threatening harm to them in some way. A normal, or maybe I should say an innocent person would, 1, look at the paper. She didn't do that. 2, get to safety. Get help, contact law enforcement or your husband or somebody that's going to come help you. Get somewhere safe. What you would not do is
call
lead the
someone
bad
to make
guy
a coded
right to
language.
the grandchildren. The
Yeah.
last thing a normal, innocent person would do is go get her little grandchildren and walk right back down the same block with them where this stranger just approached her. But that is exactly what she does. Then she gets on the phone with Charlie and says absolutely nothing about Dan Markel. His picture's on the paper.
Mm-hmm.
What she does say on the wire,
Not looking great.
by the way, is direct evidence. I know y'all like that. Some direct evidence. When Charlie asked Donna on State's 99 call A, does it involve me or other people? Well, probably both of us. That is direct evidence. If anyone in that jury room wants to acquit her, make them
great.
tell you how that is not a confession. In call B, Charlie calls back because he can't stand it. And he asks his mother, "Will you send me a picture of the bump flyer?"
Yeah, let me do this. You want to take a picture of the letter and send me a ticket?
You said nope.
No, I don't want to do that. Well, why not?
Don't want to get busted.
Why not? Normal, nice little old lady who knows nothing about this murder and has nothing to do with it.
You called her a nice
Charlie's
little
the
old
one making
lady.
you write the checks, and Charlie's the one that knows something about it. Send him
Nobody
a picture
believes
of it.
that.
He's asking for it. She doesn't want to do that. Why not?
Because she's
Call
evil.
C, Charlie calls back to say, "Don't talk about things in the apartment." Oh, obviously. Obviously, we can't talk about things in the apartment. What's obvious? Is it obvious to you?
That jury's probably like, jeez, man.
This TV was probably about 5. She's the original code talker. This TV. And look what he says. Well, they asked you for $5,000. He decodes it. He's not the one talking in code. He's decoding it and saying what
He did that a lot.
he's picking up what she's putting down.
He decoded his own secret.
There's
secret
no
language.
TV mentioned by the undercover operative that approached Donna Adelson on the street. A couple big takeaways
Yep.
for you, please. Innocent people do not talk in code. Second big takeaway, TV is code for the murder throughout this case. You got Charlie's joke, Wendy's chilling statement to Jeff Lacasse,
Yep.
the alibi of the TV, and now here we've got this TV again. A TV.
This lady is a hibachi
TV that's
grill
the
master.
alibi for Wendy. It sat broken for over a month so that a repairman could come out to be her alibi on the morning of the murder. An appointment that her parents set up for her, which was pointless because the TV was smashed and of course could not be repaired. Then she claimed she had an 18-minute phone call with Charlie about the fact that a smashed TV can't be fixed before she got in her car and went to the crime scene, where she did not get out of her car or make any phone calls or make any inquiries about what was going on at the house where her kids lived. Then Donna says that the undercover mentioned an ex-girlfriend.
Yeah. You mentioned ex-girlfriend.
Whereby, without knowing which ex-girlfriend, Charlie calls not his most recent ex-girlfriend, not the one before that. He only calls one, Catherine Magbanowa, because that's the only one he did a murder with.
Yep.
Because he probably did have a general idea what his mother was talking about.
He knew exactly what she was talking about.
When Charlie brings up going to the police, his mother says, that's not a good idea. Why not? Then instead of notifying the police, Charlie and the defendant leave the safety of her very secure building and meet at a marina
Yes,
just
yes.
300 yards from where she was approached by the undercover. They were observed speaking very intensely to each other in low tones. After that meeting, Charlie goes to Dolce Vita. This is the restaurant where he meets up with Catherine Magbanowa, and we are able to capture some of that conversation that was had there. In that recording, we hear Charlie make statements that are not only incriminating, but that also are totally inconsistent with the defense that he would later offer at trial. Pause on the wiretap here for a moment just to go to what his defense was and what we've learned about that defense. I told you earlier that he said that Magbanowa, Garcia, and Rivera acted alone. They just came to Tallahassee and killed Dan Markel, kind of in the hopes that they would get paid. There were several pieces of evidence that Charlie had to explain, and he designed a defense that he thought would do that. First, he had to explain that he's got this close connection between his girlfriend and the hitman. So the obvious defense there is, she heard me griping about Markel and she thought she was doing me a favor, so she did it on her own. Well, the problem with that is, normally you're not going to have your extortionist spend the night with you. You're not going to have the woman that has murdered your former brother-in-law spend the night with you. You're not going to inquire about her plans to go to the pool the next morning if she's, just murdered your ex-brother-in-law. So to explain these messages, he testified that he did not believe she was a part of it. She wasn't one of the extortionists. I was extorted by the killers. I had nothing to do with it. No one in my family had anything to do with it. But I thought that Magbanowa was just a victim of the hitmen too. She was a go-between for them. She was protecting him from them. All the money he and his mom were paying her, cash and checks, were going to the hitmen, not for the benefit of Catherine Magbanowa. Even the checks that were being deposited into her bank account, he said he believed she was taking out and giving the money to the killers. It was just funneling through her account so she could get insurance for her kids. So Charlie testified that he had previously mentioned to Magbanowa the $1 million offer that his family was going to give Dan Markel, and from that she deduced, he's got a bunch of money. So she ran her mouth to her associates, and her associates took it upon themselves somehow to figure out who Dan Markel is and where he was and kill him on their own.
Dang.
Per Charlie, it was Katie alone that came to him on the night of the murder and demanded money on behalf of the hitmen, with the threat that if he didn't pay, they would kill him or other members of his family. Since he didn't have that much money, Magbanowa then negotiated a layaway plan with the hitmen for him to pay her monthly to go toward this amount of money that the hitmen were demanding. He agreed. He opened up his safe, not at gunpoint or anything, and gave her all the money that was in there. And because she needed to show proof of employment to get insurance, that's why that money was funneling through her account. It was all for the extortionist. The problem for Charlie with that was that he had already agreed to put McBanois on the payroll between the two trips. You see here in June, he hadn't done it yet, but he says, no problem. Okay,
I got
so
you
he already
covered.
agreed to do it before she allegedly extorted him. Even though he had signing authority, it's this defendant that wrote this 44 checks. So if he's being extorted, why doesn't he write the checks? It's this extortion theory that we're saying that the defendant adopted when she heard Charlie's testimony and texted everyone she knew that what he just said on the witness stand was the truth. There's a concept in the law known as adoptive admissions. That's when one party makes a statement and the statement is adopted as the truth by another person. So when Charlie says in those first couple wire calls, if there's a threat, you go to the police, it's of interest that Donna doesn't say, what do you mean if there's a threat? We've been extorted for 2 years. There's been a threat for 2 years. Charlie did tell his best friend Ryan Fitzpatrick about the bump. So what I want to highlight here is the difference between their conduct during this like alleged extortion that was going on for 2 years versus the way they act after the bump, which we know was a ruse, but was supposed to be like a blackmail effort. So Charlie tells Ryan Fitzpatrick about the bump. He also tells him about the confrontation with Garcia in the roadway on July 1st, 2014, but he never previously confided in Ryan Fitzpatrick about, even though it's his best friend, about being extorted for 2 years by this girlfriend of his or her associates. Ryan also noted a major change in Charlie's demeanor around the time of the bump. He was displaying a level of stress and anxiety that was not present before the bump, evidencing that his story about being extorted the whole time is false. June Mchinda noticed these changes in Charlie's behavior as well, but she also noted a major change in this defendant's demeanor after the bump. Although she didn't know about the bump, around this time she observed the defendant to be a mess. She had a swollen face, was crying, and said she was on painkillers for stress. On the balcony of the Icon, which I'm not sure that's the right balcony, but some high-rise, the defendant told June Mchinda she felt Danny was haunting her from the grave. Why would she make that statement?
It's a sign of guilt.
Unless she felt guilty about having wronged Dan Markel. So keeping that all in mind, let's see if the other evidence in the case makes sense with this Charlie version of events that this defendant has adopted. Starting with his statements to Catherine McBanois at the Dolce Vita restaurant. Charlie says to Catherine McBanois, if they had evidence, we'd have already gone to the airport. Even if they bug your phone, you're still not talking about any of this.
Oh, man.
Like his mother, Charlie emphasizes that the co-conspirators should not talk about what they know on the phone. The cops would only bug your phone to get information about the murder, right? I mean, why?
Yeah, and there's not really much reason that the defense was able to explain that Donna was being so secretive and trying to stay off the phones. I mean, it just makes you look bad. What was she trying to hide? The defense really didn't give us any look into why she might have said that. Why didn't she want to talk to him on the phone? Why was she insistent on meeting him? Why be so secretive?
Why are we not talking on the phone if we had nothing to do with it? Why are we not talking on the phone if we're being extorted and we're the victims here? Why are we not reporting it to the police if we're being extorted and we're the victims here? If the cops are listening, we're not reporting it to the cops because we're afraid they'll come kill us if we do that. Well, talk about it on the phone. If they're listening, they'll hear and they'll know you're being extorted, but they don't do that because it's bull. Discussion about how he's going to start arming himself. So Charlie says at Dolce Vita, I'm going to start, I don't remember his words exactly, but he's going to start carrying a gun and he's prepared to shoot. And he goes through a scenario where, you know, he might have to kill somebody in his driveway and the cops will not ask him
What type of time were y'all on?
If he's been an extortion victim for 2 years, why is he just now starting to carry a gun? And then he says, if somebody comes up to me asking for money in my house, he's going to shoot them. This is the same guy that's been like too paralyzed by fear over the last 2 years to report his victimization to the police or to anyone. This is a guy of considerable resources that could, I don't know, get some muscle or some help or some something. Not just roll over and open his safe and give all his money to some girl that's not even armed. This is a tough guy that would never tolerate somebody coming up to him at his house and asking for money. But he's talking to the woman who supposedly did that exact thing, came into his house and asked him for money. He doesn't mention, well, I gave you the money, but I'm not giving this guy any money. You know, it's like they don't mention this extortion. So you see the problem.
Mm-hmm.
But this defendant doesn't see the problem. She says that it's the truth. The truth is out, thank goodness. The truth is out after we remained silent for so long. The defense does not have to prove anything, but through cross-examination and the witnesses they called, they chose to kind of suggest, you know, maybe Charlie was involved, maybe Wendy was involved. But there's no connection to our client. But Charlie's story was that he and his mom were involved in the sense that they were extorted by Catherine McVanwell, so they knew who did the killing. They just didn't speak up because they were scared, because they were being extorted. Donna Adelson calls Charlie's story the truth when it suits her to support her son and proclaim his innocence during his trial, but now she kind of wants to distance herself from that because it's a ridiculous story. It's not the truth. The truth wasn't out. Don't let her distance herself. She adopted that statement as the truth. She's stuck with it.
Please approach.
Oh, she's mad. She's gonna have to approach. Might have to take a little break here.
I'll take you to the jury room.
Oh no, what happened?
Yeah, leave everything right there on the chair, please.
Oh, we got a sidebar. It's a great closing so far. Good, Judge Everett.
Your Honor can be seated. Ms. Fulford, you may argue what you're seeking to raise.
Thank you, Judge. The comments being made in the closing argument of the state, and I don't like to interrupt closing, so I apologize for that. There have been several comments that have been made that are burden shifting and commenting on my client's right to remain silent. She's stood before this jury and said that the defense has some other version. She said this in a text, but now they're saying something different. We don't have an obligation to answer any of this. She's insinuating to the jury that we're going to come up there and provide her version of events. She chose not to testify.
What?
Argument concerning this.
Ms. Adelson has made adoptive admissions and has suggested other alternative theories that have been developed through cross-examination. I'm entitled to comment on those theories.
Yeah, absolutely.
Concerning this, Ms. Fulford, as I have heard the closing argument and the evidence, my recall of it and my notes as well as to what occurred during the trial, there were adoptive admissions as it relates to statements that occurred during Charlie Adelson's trial. While she has not testified, the prosecutor has not made any direct comment on her not testifying in this trial. Also, as well, it is clear she has no burden to prove anything. The state is entitled to argue reasonable inferences from the evidence in the record. We will take a break at this time. If the defendant needs to use the restroom, bailiffs, please take her. If anyone else needs to, please stretch your legs or use the restroom at this point as well.
I think we're gonna stretch our legs a little bit. What do y'all think about this? Let me know in the comments in the chat. Is it gonna be guilty or not guilty? I don't think the jury will start deliberating today. What time is it? They might start deliberating today. We'll have to wait and see how closing arguments for the defense goes. So what we're gonna do is we're gonna finish this up tomorrow because I don't think we'll have a verdict today. I would be shocked, to be honest. Let me see what y'all are saying. Shout out to all 1,100 of you that are in here. 1,400 of you like the video. Dang, y'all are showing major love. I had a couple super chats I needed to read, and we're gonna get y'all up out of here for today, and we'll cover the rest of this tomorrow. Amy with the cake is shaking it like a salt shaker in here. Shout out to Amy for the super stickers, the cake, the salt shaker, and the peach. Oh my goodness, it's almost lunchtime. Get all that goodness over here. Shout out to the real deal Neil Floyd, the real deal Neil in the building. Says, can you save me a spot for tomorrow night? We're getting in there early. Love y'all, family. He said, oh, and she guilty as F. Yep. Shout out to Floyd. Amy in there dropping some more cake. Thank you to everybody who sent in super chats. I appreciate y'all. Floyd, Les Cleaver, Slim Life, and then of course the awesome, amazing Amy. If y'all haven't yet, please do me a favor, subscribe, hit the notification bell so you don't miss any time that we go live. We'll be back tomorrow morning and covering the rest of the closing arguments. Should be interesting. I think the state has made a wonderful, precise, clean case. We'll see what the jury decides. Y'all know what to do. Keep growing, keep pushing, keep classy. Have a great day. We gone. Peace.